Just a reminder, we need all electronic devices turned off in the courtroom. And thank you, ladies and gentlemen. I'll now ask you to give your attentions to Mr. Bogar, who will give closing argument for the defense. Mr. Bogar, you're mic'd up, right?
Yes, I am, Your Honor.
Thank you.
May it please the court, counsel, ladies and gentlemen of the jury. Before I begin, I just want to cover a couple things right out the gate. First, the state gets to talk again. When I sit down, that's the last you're going to hear from me. They get a chance to rebut anything that I say. It's not that I'm not going to want to come back up. It's just what the rules are. So when I'm done speaking, that's it. That's the end of the state's case. Now, ladies and gentlemen, I don't envy your task. As human beings, this is a tough case to hear. To hear about a young man who loses what he lost. To hear about a mother who was met by the chaplain. That's heavy stuff. As humans, we're endowed with compassion, empathy, with sympathy. And that's the part of a person that can put themselves in somebody else's shoes. Ladies and gentlemen, this is a court of law. The other part of humanity is reason. It's logic. It's taking our experiences and applying them to the facts and the law, as you've heard today and over the last few days. The challenge in a case like this is your duty. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. Ladies and gentlemen, you sit here in judgment of the state's case. Whether they have proven to you every element of every charge that they have chosen to bring beyond a reasonable doubt. It's their burden. Now, in many closing arguments, a defense attorney like me, I'll often use an analogy to describe proof beyond a reasonable doubt, but that's not necessary in this case, ladies and gentlemen. They proved bail jumped. And not just because at opening I said that she wasn't in court, but they actually proved it with evidence. They showed a charging document. They showed when she was arrested, 4 months after the events that bring us here. They showed that even though she's presumed innocent right now, then just as she is right now presumed innocent, that she had to follow conditions and she didn't follow the rules. and gentlemen, that is proof beyond a reasonable doubt. She did not follow the rules. She missed court. They proved bail. But ladies and gentlemen, she is not the only one who did not follow the rules. You heard a substantial amount of testimony about how important it is to follow rules when conducting scientific analyses, when doing scientific processes. The rules and the protocols are important so that reliable, credible, and accurate results can be drawn. You heard from Bruce Siggins about how important it is to make sure that he's doing everything right, because he doesn't know what's coming to him, and he doesn't know what happens to the substance after it leaves his desk. Everything has to be done right, so the right, the correct, valid, and reliable result can be drawn. You heard from Asa Lewis. Hours of testimony about all of the checks that they have because of the thousands of cases and substances and vials and materials submitted to the various labs through the state. Ladies and gentlemen, when Deputy Luque was called to the hospital, he was called for a scientific reason, to conduct a drug recognition expert evaluation. And he threw those rules aside. He didn't do the job that he was told to do, that he'd been trained to do. He didn't do what they told him to do. He had options. He could have had another deputy start writing the search warrant affidavit. He conducted the evaluation that he was supposed to do. Here's a novel idea. He could have taken her blood. She volunteered it. So when we're talking about this time frame, that's 7 hours later, that's on them. There's nothing stopping her from taking her blood at that point, conducting the DRE analysis, and then getting a search warrant and doing it all again. That was a choice. That was a choice. Because Deputy Luque has gotten into, apparently, the habit of going into the grocery store with his wife, and she'll point out somebody who's acting a little bit odd, and he draws a conclusion. What's that person under? He doesn't need 12 steps. He doesn't need the protocol. But that's what the science says is necessary. That's why we have a DRE program, because it is based in science, for validity, for reliability. Peer review. We heard about that from Asa Lewis. Publications. Important step in the process. Making sure that you follow the rules so you can get a valid result. Now, ladies and gentlemen, prosecution, they alluded to a lot of the things that have been going on in my head as to why it hadn't happened, and I assume it's been going on in your heads too. Why, if you have the training, use it. That was his job. What he is asking you to do, and what the state is asking you to do, is to excuse him for not doing his job because he short-circuited it. And if he had done his job, who knows what he would have found. Because part of the DRE program is to help rule things out, like medical injuries. Somebody who'd just been in an accident at 45 miles an hour. So he could, at most, have potentially ruled out some controlled substances. But if he doesn't complete the protocol, and he can't tell you which substances he suspects she's under the influence of, he certainly can't tell you what's from the accident and what's from his suspicion. And the question isn't, frankly, it isn't what was in her system allegedly at some point in the future. The question is what was in her system, if anything, at 7 o'clock in the morning. I didn't hear any EMS testimony, any of the medics. There's no evidence that any medics thought she was under the influence of any. Deputy Luque. So he has 20-some-odd years experience. In his opinion, that at the time he had absolutely no reason to think she was under the influence of anything, no reason to suspect any crimes. That's supposed to be thrown aside. And you're supposed to listen to Karen Nelson. Ladies and gentlemen, 5 days after these events, Miss Nelson spoke to Deputy Young. Talked about pot. Talked about Justin. Didn't talk about methamphetamines. Now, almost 2 years later, given all the publicity she apparently remembers, based on prior experience, seeing other people using, while she was most likely also using. She admitted she'd been using in the past. That's when she knew what people did and how they acted. She was a user, and she's watching other people use. And somehow, that's supposed to be proof beyond a reasonable doubt. When she didn't tell the deputy who was investigating the crash 5 days later. And they talked about the same kind of stuff. It is your province alone to judge every witness's credibility. But you can take into account your common sense and your real-world experience. And if somebody is beside themselves with concern, the logical conclusion is that they tell everything. They don't hide stuff. They don't forget things like that. It doesn't just magically disappear, but it can magically reappear when questions get raised. Now, you know, we didn't really spend too much time looking at this. I'm going to move it around. It's not apparently operating very well today. This is the request for analysis. This is Exhibit 62. DRE, request for analysis. DRE opinion, none. No opinion. Sample collected, June 12th, 2013. June 12th, 2013. They sent blood up to the lab. She had opiates pumped into her system. They didn't review her medical record. They don't know what was pumped into her system after Deputy Luque walked in and contacted her. He was off writing a search warrant. Didn't go back and check her medical report. Where are the opiates? They were in her system. We know that. She had a broken arm. She'd been pumped full of fentanyl and dilaudid, and there were no opiates in the blood that they tested. And the sample that the collection sheet says was collected June 12th. Ladies and gentlemen, if there were no opiates in her system, we got some pretty big problems. Because we know those were in her system. They weren't in the blood. I don't know. I can't explain that. But here's the thing about explaining stuff. Their burden. Deputy Young, Deputy McKay, and Mr. Vu. They were the two primary investigating officers and the deputy prosecuting attorney responsible. It is their burden, not mine. It is their job. Because every defendant, Ms. Johnson, somebody charged with a simple driving offense, everybody, they are presumed innocent. And it is their job to answer every question that you have until you're satisfied beyond a reasonable doubt. If they don't do that, if they can't explain the lack of opiates, if they can't explain to your satisfaction how you should just accept the word of somebody who used to use methamphetamines but not the first deputy who was there without any EMS testimony, and then a partial investigation done in an unscientific manner, just like you're at the grocery store evaluating folks as they walk by. That means they haven't met their burden. And they haven't done their job. Now, Deputy Young was at the scene, and we've heard some conflicting stuff about what happened. Deputy Young, when I say he was at the scene after. He conducted the investigation later that day and in the following time. So, during opening, Mr. Vu described this as a Dukes of Hazzard situation. Okay? Implication being cars flying through the air. We're talking a couple of inches at most. There's been a lot made about reaction time. Ladies and gentlemen, this is a yardstick. I put this binder at 24 inches. That's the estimated depth of the ditch right before the culvert. It was estimated to be about 18 inches. It's 35 inches there. Office Depot, regular old yardstick. 2 feet. In a Nissan Altima. 45 miles an hour. In a ditch. 2 wheels in a ditch. What in the world does reaction time have to do with any of this? What could have happened? This is a city car. This isn't a jacked up Chevy truck ready for the tough trucks at the fair. It was a Nissan Altima. It got sucked into the ditch when she reached down to pick up her cigarette. They make a great deal about reaction time, but 2 feet down in a city car, car's not just magically coming out. And at 45 miles an hour, there's nothing to do. Now, Deputy Young conducted a substantial investigation that went on for months because he was looking to find out if there was any evidence Shon Johnson knew Justin was there. There was no evidence. He looked. There wasn't any. So this isn't some kind of situation where there was anything being hidden. She talked to the officers, 2 of them. And what she told them, the actual investigation supports it. She said she was going 45 miles an hour in a 50. She was on her way to work. 7 o'clock in the morning. did make admissions regarding the previous Saturday, but there's absolutely no evidence of intoxication that morning. She leaned down to pick up a cigarette. Wheel turned to the right. Anybody ever play Nintendo back in the day? And you start moving the controllers. Ever see your kids? Leaned down to pick up a cigarette, drifted to the right, ditch. Sucked into the ditch. That's what happened. Now, Mr. Boo just talked about the length of the grass and what happened when she came up. 45 miles an hour, things go by pretty quickly. And when your right wheels are 2 feet down, now you know you're in the ditch and you come up, things are going by really fast. There's a lot of grass. Leaned over to the right as well. So there's no conclusion to be drawn about reaction time, about whether or not she saw grass. There was grass everywhere. No indication of any of which grass she saw or anything. There was grass everywhere. Now I have a couple of questions, and these are questions that I've written down, primarily during Mr. Vu's closing. These are questions. You make the decision as to how important they are, or if they're important to you at all. Where are the opiates? Where's any testimony about dilation resulting from getting hit in the face from an airbag? Where's the EMS testimony? If she was obviously impaired, where's the EMS testimony? Where's the medic testimony? Where's the nurse testimony? Where's the testimony from somebody who wasn't involved in the investigation? Why didn't they follow the rules? Why is there a fight when everybody agrees the deputy didn't follow the rules? Why are we fighting about, what questions we get to ask? Why doesn't Deputy Gosh's opinion count? What about his experience? 20 some odd years. No direct evidence. Somebody admits they're an addict and they're in the hospital, and you know that somebody's laying in the ditch. Why don't you search their clothes, especially when they admit possession of methamphetamines on their person when they're under arrest? Because there's a 7-hour window. Why don't you search the clothes? Ladies and gentlemen, I keep asking, why does the state overstate its case? Why was this presented as a Dukes of Hazzard situation when it wasn't? It wasn't. A couple inches. 45 miles an hour sucked into the ditch. Why is there a statement that she got behind the wheel that morning after consuming methamphetamines when there's no evidence of it? There's no evidence. Why was there a statement just now that giving her the benefit of the doubt regarding her speed? That's what the evidence showed. Okay? That's what the objective analysis showed. The math showed she was going 34 to 44 miles an hour. So this isn't giving her the benefit of the doubt. That's their investigation supporting what she told them right out of the gate. Now, you've been instructed that you can't use the fact that she hasn't testified against you or to you against her today. That's true, you can't. But remember, she waived her right to remain silent. Twice. She offered her blood. She cooperated. She answered the questions that they asked. The investigation actually supports what she said. The speed, everything. So, why would somebody not speak? Why would somebody not testify? Well, the investigation supports what she said, and 4 months later, they went out and arrested her. Every piece of objective evidence supports her version. Every piece of evidence gathered that followed the rules supports her version. Every piece of evidence that makes sense supports her version. There were no opiates in that blood. And she'd had dilaudid and fentanyl opiates pumped into her. That's why she didn't testify. They didn't listen. Her side of the story was out, and they knew it. They didn't listen. Now, this is instruction number 8. Mr. Vu talked about some of the parts that are in the beginning, so I thought it appropriate to underline the parts that he didn't read out to you. It is not unlawful for a person to consume drugs and drive a motor vehicle. The law recognizes that a person may have consumed drugs and yet not be under the influence of it. So this is the law. This is what they have to overcome. At 7 o'clock in the morning. Not a blood draw 7 hours later that doesn't match the physical evidence. Not an incomplete investigation 3 hours later when they could have done a complete investigation and taken the blood. This is what they have to get over. And this is what they haven't. Ladies and gentlemen, the cold hard truth of this case. When I asked Deputy Young about that post and whether or not he checked it, I wasn't asking whether or not that could explain the dents on the car. But he agreed he was finding evidence to support the conclusions that they'd already drawn, that Shon had hit Justin. And the fact that he was found with that debris trail supports that. I don't see any other rational inference from that. Ladies and gentlemen, they already had their conclusion. When they started this investigation, when Deputy Young got to the scene, when Deputy Bouquet went to the hospital, and at every point after Justin was fortunately found, they had their conclusion. They knew about the methamphetamines. So that must mean that she was under the influence at that time. But they didn't follow the rules. So the evidence is not consistent and it is not sufficient. Deputy Bouquet knew the conclusion that he was going to draw when he went to the hospital. That's why he didn't do the complete analysis. Had he done the complete analysis, he might have had to conclude otherwise. And there were no opiates in the blood that they tested. Ladies and gentlemen, what happened to Justin was not his fault. And it could have happened to anybody. And as humans, we want to sympathize and we see our kids or ourselves. Ladies and gentlemen, anybody could also be sitting in that defendant's chair who's ever reached down to pick up a pacifier for a crying baby or chase that last French fry in the bag. Because nothing changed in terms of the physical evidence. Nothing. Deputy Gosh got to the scene. 20-some-odd years experience. Contacted Miss Johnson. Enough to get the information that he got from her. And he drew the conclusion that no crime had been committed. He had absolutely no reason to call out a DRE. Not reckless driving. no other crimes. There's no EMS testimony. We heard Deputy Luque, certainly medical technicians have some knowledge of intoxication. There's none. The only evidence that the state has for 7 o'clock in the morning is the word of somebody who used to use meth and heroin and didn't tell Deputy Young about it 5 days later. That's it. Nothing's changed. It wasn't Justin's fault. And our heart goes out to him. But that ain't the question before us today. It's not the question before you. Your duty is to evaluate the objective evidence, or lack of evidence. It's a duty. Anybody could be sitting in that chair. The evidence hasn't changed. There is no evidence of intoxication at 7 o'clock in the morning. The state has not overcome its burden. The cops who went out to the scene had already drawn their conclusions, and Deputy Luque, when he went to the hospital, knew what he was going to conclude because he'd already talked to Deputy Dosh and Deputy Young, and he knew about it from that time. And if he does the full investigation, he might have to draw another conclusion, maybe even determine she's not under the influence, and that doesn't fit the conclusion that they've already drawn. Ladies and gentlemen, there's no opiates in the blood. Something ain't right. And they haven't gotten over their case. They haven't gotten over their burden. Ladies and gentlemen, Shon Johnson committed a crime of negligence. She didn't show up to court. They proved that. You draw your own conclusions from the bag or the purse. But this case is about intoxication at 7 o'clock in the morning, and they did not prove it. Just didn't. Ladies and gentlemen, your duty requires you to objectively analyze the evidence, to think about what phrases like that means. That no person shall be deprived of life, liberty, or property without due process. A law and due process requires you to do your duty. Ladies and gentlemen, the only conclusion to draw in this case for vehicular assault DUI is not guilty. Put your passions aside. Do your duty. If you find her not guilty, throw away the special allegation form. You don't need it. Ladies and gentlemen, she's not guilty. I want to thank you for your time. I know this has been a substantial burden, 4 days. Thank you. Thank you very much, ladies and gentlemen.
Thank you, Mr. Bogar. And now, ladies and gentlemen, as the microphone gets switched over to Mr. Vu, do you wish to have a rebuttal, Mr. Vu?
Very quickly, Your Honor.
All right. The state has the burden of proof, so they get the last word in these proceedings and have an opportunity for rebuttal.
That's all. I promise this will not take 2 hours. Be very quick.
Thank you.
Just because you keep on repeating, she's not guilty, doesn't mean that she is actually not guilty. Okay? Keep on repeating that. I guess defense believes that fact, but it actually does not prove anything, or it does not claim to be anything, except for the fact that they hold the position that the defendant is not guilty. I will start with this. Defense claims that the state only proved the crime of bail jump. So it appears that defense is conceding that the defendant committed the crime of bail jump. If they're willing to concede that, the meth possession is so much clearer than that. Why can't they concede that? I mean, is there any doubt, not just reasonable doubt, is there any doubt that the methamphetamine belonged to her, was in her purse, that she possessed it? No. And defense didn't even concede that. And asked you to weigh that. So that should clue you in on where the defense is coming from. Now, in these criminal cases, oftentimes, a lot of times, when the investigation is complete, is done, and we get to this point, and we go to trial, and there's nothing that the defense can do, the tactic is to attack the investigation. That's because they can't attack the evidence. They can't, refute people's testimony. So what other tactic can the defense employ? Is to attack the police officers, attack how they conduct their investigation, and poke holes in it. And that's all this has been from day one. The defense tactic has been to attack the investigation by the police in this case. I submit to you that oftentimes that does not work very well because you can see through all of that. Okay? You make the determination of whether or not the investigation in this case was adequate, was complete, was thorough, was proper. And the evidence that was gathered by the police in this case clearly shows, and you be the judge of that. And this Monday morning quarterback that the defense asked you to engage in, okay? Well, that's just exactly that, Monday morning quarterback. It is not proof that the police didn't do their job or that the police had already prejudged or made up their mind prior to conducting their investigation. Now, let's talk about Karen Nelson. So the defense cast Karen Nelson in a pretty negative light. And they try to make hay with the fact that she didn't tell Detective Young about her observations and stuff from the defendant 5 days earlier. But think about this, okay? Karen Young was an addict, had been clean and sober for, 12 years? I didn't write it down, but she remembers her clean date. And that's pretty significant for someone who's an addict and was able to kick it. She's very proud of that. So if she's been clean and sober for 12 plus years, you think she wants to bring all that back up? Okay? You think she would, on a telephone call with a police officer she's never met before, remember, she had left the scene, never met any police officers. Suddenly, a police officer calls her up and says, "Ma'am, this is Detective Todd Young, Sheriff's Office. I'm investigating this crash. I understand you were there. I'm asking you some questions." You think she's going to volunteer the fact that I was an addict 12, 15 years ago, and this is what I observed. This is personal information from her past that she's not proud of. She is absolutely not proud of. But she did think about it. She did reconsider. And she had the courage to walk through those doors, get on that stand, and testify in front of everybody here in this courtroom, including you, complete, total strangers, and admit, yes, I am an addict. And then tell what she observed. That took some guts. So that is not something to be taken lightly. And that's how you should look at her testimony, not the fact that she, quote, hid that and then suddenly came forth because of all the press coverage. You think she wants, seriously, think about it. If she wants to be captured by the press, if you will, or covered by the press, and because this is her 15 seconds of fame and glory, would she use this avenue to do that? Admit to everybody out in public and the media that, yep, I was an addict, I used XYZ, I used meth, I used heroin, and things like that? No. This is personal information that she did not want to divulge, but she only came forward because it was the right thing to do. Okay, let's talk about the defense's repeated claim that there were no opiates in the defendant's blood. Okay, remember what Asa Lewis said. I asked him about the half-life of Dilaudid and fentanyl and whatnot. So let's go back to my timeline. Here's my timeline. Okay, let's start with 10 o'clock, because that's when Detective Luque arrived at the hospital. Just before that, the defendant was given, I believe, Dilaudid, and prior to that, it was fentanyl. So between 10 and 2, 4 hours. Okay? No indication that she was given any more pain medication between that time. What's the half-life of Dilaudid and fentanyl? Mr. Lewis said it was about 3 hours. Hello, 4 hours had elapsed. And I asked him about at what level his instruments at the toxicology lab picks up or detects these drugs, these substances. He said 0.02. So, I'm sorry, he said 0.01. I stand corrected. But the dosage level is typically at 0.02 in the hospital. Well, if the half-life of these drugs have already passed, then that level that his instruments can detect has dropped below that level. Therefore, it's not picked up by the screening that they do. No, however, another way to look at that is, remember, we know when the defendant was provided or given these opiates. Somewhere around 10 o'clock, right? And 4 hours later, no opiates were found in her blood. But yet, what was found in her blood? Methamphetamine at a concentration of 0.11 milligrams per liter. So what does that show? obviously extremely high, well, way over therapeutic levels. So just because opiates were not found in her blood does not mean anything, except that they just weren't found. It does not take away from the fact that meth was found in her blood at that concentration. The defense tries to make hay about this apparent error in the handwritten collection date, or date collected 6/12/13, and it was sent to the lab 6/17/13. Is there any evidence that her blood was collected anytime after June 10, 2013? No. Her blood was collected on June 10, 2013, just after 2 o'clock, just like Detective Luke Kay testified to, just like Kristen Johnson testified to. Obviously, this was an error when someone filled this in. Okay? I submit to you, this was probably when Detective Luke Kay got the blood vials out of his locker to submit it to the crime lab on 6/12. I'm not going to argue or dispute or try to convince you that the defendant was not reaching over to retrieve a cigarette, and that, that she was not telling the truth or whatnot. We'll never know that. But the fact of the matter is, Detective Young searched the area and did not find a cigarette, and did not find a burn mark, did not find a cigarette butt in that area. So she may have reached over, she may not have, it doesn't matter. The fact of the matter is, she went off the road and crashed into Justin, and she was impaired at the time. Defense claims that anybody can be sitting in that chair just because they reach over to get that last French fry or reach for that pacifier. Sure. If they engage in the same conduct as the defendant, heck yeah. Okay? An accident is an accident. True, I agree. But this was no accident. An accident is something that you can't plan for. Okay? Something that you can't foresee. Something that you can't predict. If you know the hazards, if you know the risks, and you still engage in that conduct, and the risk or hazard happens, that is not an accident. That is something that's negligent at a minimum. Because you know that risk, you know that hazard, but yet you still engage in that conduct without mitigating the risk. In this case, the defendant admitted she was an addict. She had used recently. She was still impaired. She was still under the influence of that drug. She got behind the wheel of her car and she drove. And her driving caused the injuries to Justin Carey. That's all there is to it. Those words are sacred. No person shall be deprived of life, liberty, or property without due process of law. That's why we're all here for the past several days this week. This is the process that's due the defendant. And it's obviously grounded by our law from day one of our founding fathers. And the standard that the state has to meet in this exercising of due process of law is that the state has to prove the elements, like I said, beyond a reasonable doubt. And this is what it means in terms of proof beyond a reasonable doubt. However, look at the last paragraph. I highlighted because I asked you to consider that. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. What does this not say? This does not say that the state has to prove the elements of the crime by a standard of proof beyond all doubt. Because those words, this standard, were all developed, came up with by people, human beings. That standard, these words have been in existence for centuries. Back whenever, they didn't have DNA science. They didn't have, all of these high-speed, high-tech, gee-whiz stuff that we see nowadays on CSI, at the crime lab. And that's why the standard is such, is that the system, the law, expects due process to be followed with a reasonable standard, not an unreasonable standard. Because if it were proof beyond all doubt, okay, we wouldn't have people. We would just have a machine, a computer, feed in all the information, all the evidence, whatnot, and let the computer do its calculations and spit out the answer, and that's where we're at. No, we don't have that. We have people to analyze, evaluate, assess the evidence, apply the standard, and come up with your decision. And I charge you with that duty. It is a solemn duty. I ask you to do the right thing, the just thing. Thank you. I'm done, John.
Thank you. Ladies and gentlemen, now that you've heard the court's instructions on the law and the closing arguments, you're ready to begin your deliberations. You're free to conduct your deliberations in any way that seems suitable to you and is consistent with the instructions I've given you. However, I have a few suggestions that may help you proceed more smoothly. Unlike the instructions as to the law, these remarks are only suggestions and will not be given to you in writing. As you deliberate, consider the following guidelines. Respect each other's opinions and the different viewpoints each of you brings to the process. Don't be afraid to speak up and express your views. Be patient and generous in allowing everyone an opportunity to speak. Differences of opinion are healthy. They bring the evidence into focus and bring out points you might not have considered. Listen carefully to each other. It's okay to change your mind, but don't allow yourself to be bullied into doing so, and don't bully anyone else. Don't rush into a verdict to save time. This case deserves your thoughtful deliberation. The jury system depends upon it. Each of you must decide the case for yourself, but you should do so only after you've reviewed the law, carefully considered all the evidence, discussed the issues fully and fairly with the other jurors, and listened to their views. Discuss the law and evidence to your satisfaction before you take a vote. You should organize your discussions in whatever way you believe will be productive and fair. Some juries begin by reviewing the court's instructions on the law because those instructions identify each element that you must consider. Others begin by proceeding around the table with each juror in turn identifying the issues or concerns he or she would like to have discussed, because that encourages free expression by all jurors before positions are taken. There is no set way to conduct a vote. You might vote by a show of hands, by voice, or by written ballot. Use a method that will encourage each juror to freely express opinions and conclusions. Finally, I'll remind you that these remarks are merely suggestions. I hope that they are helpful to you. Nothing I've said or done should suggest to you what your verdict should be. That's entirely for you to decide. Now, at this time, Mr. Koski and Mr. Flock, you were our alternate jurors in this proceeding. In a moment, I'm going to dismiss you provisionally and conditionally. That means that you're still under the court's orders and instructions until this jury has reached a verdict. If, heaven forbid, something were to happen, we might need to call one of you back into service to complete the deliberation and verdict process. Once this jury has reached a verdict, then you'll be released from the court's further obligations. I want to thank you for participating. It's frustrating when you come this far and if you don't get to be a part of the final process. But at this time, I'll ask you to please retire to the jury room. You're free to take your belongings. Please make sure Rhonda has your contact information in case we do need to get in touch with you. Thank you. And then as soon as they are back there, ladies and gentlemen, having given all these instructions, I'll ask you now to please retire to the jury room. Take your notepads with you this time. Sir. All right, thank you, counsel. Please stick around to sign any paperwork that may be needed with the clerk. Please also provide to make sure you have phone numbers with Rhonda so that she can get a hold of you on short notice. We're going to let the jury go as long as they want, and then we're prepared. We have contingencies in place so that if they want to stay into the evening, they'll be welcome to do so. We'll get them dinner if need be to allow them to continue the process. We're really going to leave it up to them. So again, please make sure that you can be in touch and be back to the courtroom within 10-15 minutes notice. Okay? Thank you.